What's going on YouTube? Listen up, young elder gang. This is Shalonda Williams, one of Big Mama's daughters, the lawyer and real estate agent at You with Another Banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In the following video, you will find history, definitions, scripture information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for educational and informational purposes only. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. All right, let's get started. You need to watch this if you struggle with estate planning. Here's how a trust can make it easier. A trust is a legal arrangement where one person, the grantor, places assets under the care of another, the trustee, to benefit a third party, the beneficiary. Why use a trust? They ensure your assets are distributed as you wish, can offer tax benefits, and help avoid the probate process. Two common types are living trusts set up while you're alive, and testamentary trusts created by your will. Trusts help protect and manage your wealth for future generations. Consult an attorney to see how a trust can work for you. A trust is a legal relationship in which the owner of property, or any transferable right, gives it to another to manage and use solely for the benefit of a designated person. In the English common law, the party who entrusts the property is known as the settlor. The party to whom it is entrusted is known as the trustee. The party for whose benefit the property is entrusted is known as the beneficiary, and the entrusted property is known as the corpus, or trust property. A testamentary trust is an irrevocable trust established and funded pursuant to the terms of a deceased person's will. An inter vivos trust is a trust created during the settlor's life. A trust is a legal arrangement that allows a person to transfer assets to a trustee to be held and administered for the benefit of a beneficiary. Trusts can be used to distribute assets to loved ones, charities, or future generations. How a trust works? Grantor, the person who transfers assets into the trust. Trustee, the person who holds the assets and manages them for the benefit of the beneficiary. Beneficiary, the person who receives the benefit of the assets. Why people use trusts? Estate planning. Trusts can help ensure that assets are used as the grantor intended, both now and in the future. Tax efficiency. Trusts may offer tax benefits in certain circumstances. Avoiding probate. Assets held in a trust do not need to go through probate when the grantor passes away. Types of trusts: living or testamentary, revocable or irrevocable, and funded or unfunded. What is the purpose of a trust? Some of the ways trusts might benefit you include protecting and preserving your assets, customizing and controlling how your wealth is distributed, minimizing federal or state taxes. The trustee is the legal owner of the assets held in trust on behalf of the trust and its beneficiaries. The beneficiaries are equitable owners of the trust property. Trustees have a fiduciary duty to manage the trust for the benefit of the equitable owners. Trustees must provide regular accountings of trust income and expenditures. A court of competent jurisdiction can remove a trustee who breaches their duty. Some breaches can be charged and tried as criminal offenses. A trustee can be a natural person, business entity, or public body. A trust in the U.S. may be subject to federal and state taxation. The trust is governed by the terms under which it was created. In most jurisdictions, this requires a contractual trust agreement or deed. To create a trust, you need to identify your beneficiaries, choose a trustee to manage the trust, determine the terms of the trust, draft legal trust documents, transfer your chosen assets into the trust, funding, and have the documents signed and notarized. It's highly recommended to consult an attorney to ensure the trust is properly structured and legally valid. Key steps in creating a trust. Decide on the type of trust. Choose between a revocable living trust, where you can modify the terms during your lifetime, or an irrevocable trust, where you cannot change the terms once established. Identify beneficiaries. Determine who will receive the assets in the trust upon your passing. Select a trustee. Appoint a responsible individual or entity to manage the trust assets and distribute them to the beneficiaries according to your wishes. Inventory your assets. List all your property and financial accounts that you want to include in the trust. Draft the trust document. Create a legal document outlining the terms of the trust, including the beneficiaries, trustee, and how assets will be distributed. Fund the trust. Transfer ownership of your chosen assets into the trust. Sign and notarize. Ensure the trust document is legally binding by signing it and having it notarized. Important considerations. Consult a lawyer. Complex estate situations often require legal guidance to create a trust that aligns with your goals and state laws. Succession planning. Designate a successor trustee to take over if your primary trustee becomes incapacitated or dies. Tax implications. Understand potential tax consequences associated with transferring assets into a trust. A living trust is a legal document created while someone is still alive, allowing them to designate a trustee to manage their assets and distribute them to named beneficiaries according to their wishes after their death, often with the goal of avoiding the lengthy probate process involved in settling an estate through a will. It can be either revocable, changeable during the grantor's lifetime, or irrevocable, cannot be changed once established, depending on the terms set up in the trust document. Key points about a living trust. Purpose: to control how your assets are distributed after your death and potentially avoid the probate court process. Creator: the person who establishes the trust is called the grantor. Trustee: the individual or entity chosen to manage the assets in the trust according to the grantor's instructions. Beneficiary: the person or people who will receive the assets from the trust. Revocable versus irrevocable. Revocable living trust: the grantor can make changes to the trust during their lifetime. Irrevocable living trust: once established, the trust cannot be changed without legal intervention. Benefits of a living trust: avoids probate. Assets held in a living trust can be distributed to beneficiaries more quickly and privately than through a will going through probate court. Asset protection: can potentially protect assets from creditors in certain situations. Control over distribution: allows the grantor to specify how and when assets are distributed to beneficiaries. Important considerations. Legal advice needed. Consulting with an estate planning attorney is crucial to ensure your living trust is properly structured to meet your needs. Transferring assets. To be effective, you must transfer ownership of your assets into the trust. Tax implications. Depending on the type of trust, there may be tax considerations to review. The public side of the financial system refers to the part of the market where securities, like stocks and bonds, are openly traded on regulated exchanges, accessible to the general public, meaning anyone with the means can buy or sell them, unlike the private side, where investments are restricted to a smaller group of qualified investors and may have less transparency. Key points about the public side: open access. Anyone can participate in buying and selling securities on public markets like the New York Stock Exchange, NYSE, or NASDAQ. Highly regulated. Public markets are subject to strict regulations to ensure fair trading practices and investor protection. Public information. Companies listed on public markets are required to disclose a significant amount of financial information to the public. In contrast, the private side of the financial system. Limited access. Investments are typically only available to sophisticated investors or institutions. Less regulation. Private markets may have less stringent regulations compared to public markets. Restricted information. Private companies may not be required to disclose as much financial information as public companies. The private side of the financial system refers to the part of the market where investments and transactions occur between a limited group of qualified investors, like institutional funds or wealthy individuals, outside of public stock exchanges, typically involving less regulation and with limited liquidity compared to public markets. Essentially, where private equity, venture capital, and other alternative investments are traded, often through private placements to raise capital for companies not publicly listed on a stock exchange. Key points about the private side of finance. Limited access. Only qualified investors with significant wealth or institutional status can participate in private markets. Less regulation. Compared to public markets, private transactions often have less stringent regulatory oversight. Lower liquidity. Due to the limited investor pool, Buying and selling assets in private markets can be more difficult and less frequent than in public markets. Investment vehicles, private equity funds, venture capital funds, and private debt funds are common ways to access the private market. Example of private side transactions: a startup company raising capital through a private placement to a group of angel investors. A large pension fund investing in a private real estate fund. A private equity firm acquiring a company and taking it off the public stock exchange. We tend to use the word public to refer to financial markets that are open to all with the disposable wealth to trade in them, and the word private to refer to the segment of the financial market that is closed to all but the wealthy and financial institutions. Statutory law is a written law created by a legislative body, such as Congress or a state legislature. Statutory laws are also known as statutes or codes. Federal statutory law, acts passed by Congress and signed into law by the President. State statutory law, acts passed by a state legislature and signed into law by the state governor. Statutory laws are subject to constitutional law. Judges may interpret the law, which can create a precedent for future cases. The legislature may change the statute based on precedents set by judges. Differences from other types of law. Statutory laws are different from regulatory, administrative, and common law. Regulatory laws are created by executive agencies. Common law is created by court decisions. Equity jurisprudence is the study of the rules and principles that govern courts of equity and how they are applied to cases. It's a branch of legal science that allows for more flexible outcomes when the strict application of the law is not appropriate. In the field of jurisprudence, equity is the particular body of law developed in the English Court of Chancery with the general purpose of providing legal remedies for cases wherein the common law is inflexible and cannot fairly resolve the disputed legal matter. Conceptually, equity was part of the historical origins of the system of common law of England, yet is a field of law separate from common law, because equity has its own unique rules and principles, and was administered by courts of equity. Equity exists in domestic law, both in civil law and in common law systems, and in international law. The tradition of equity begins in antiquity with the writings of Aristotle, Epikeia, and with Roman law, Equitas. Later, in civil law systems, equity was integrated in the legal rules, while in common law systems it became an independent body of law. How it works? Origins. Equity jurisprudence originated in the English Court of Chancery. Purpose. Equity provides legal remedies when the common law is inflexible or unjust. Procedures. Equity courts have unique procedures and remedies, often without a jury. Remedies. Equity remedies can include injunctions or monetary compensation. Antitrust. Equity jurisprudence can be used to determine if a restraint on competition is legal. Contracts. Equity remedies can be used in contract law, such as when a wronged party receives money as compensation. Importance: equity jurisprudence allows for more flexible and just outcomes. It's an important part of the legal system. Operating in equity essentially means actively managing a company or portfolio of companies by leveraging equity investments, which involves acquiring ownership stakes in businesses to improve their performance, increase their value, and eventually generate returns by selling those stakes later on. This is typically done by private equity firms through processes like due diligence, investment proposals, and actively overseeing the operations of the acquired companies to drive growth and profitability. Key aspects of operating in equity: identifying target companies, thoroughly researching and evaluating potential companies to invest in, considering factors like market potential, financial health, and management team capabilities. Due diligence, conducting in-depth analysis of a target company's financials, operations, legal structure, and market landscape to assess its viability and potential risks. Investment proposal, presenting a detailed plan to potential investors outlining the investment thesis, expected returns, and strategy for improving the target company's performance. Raising capital, securing funding from investors to acquire ownership stakes in target companies. Active management, once invested, actively engaging with the target company's management team to implement strategic changes, improve operational efficiency, and drive growth initiatives. Value creation, focusing on strategies like cost reduction, market expansion, mergers and acquisitions, and operational improvements to enhance the value of the target company. Exit strategy, determining the best way to realize returns on investments, such as selling the shares in an IPO, selling to another company, or through a secondary market sale. Key players in equity operations: private equity firms, companies that pool capital from investors to invest in privately held businesses. Investment professionals, analysts and managers within private equity firms who conduct due diligence, evaluate investment opportunities, and oversee portfolio companies. Important considerations when operating in equity: risk management, assessing potential risks associated with investments and implementing strategies to mitigate them. Alignment of interests, ensuring that the interests of investors, management teams, and other stakeholders are aligned. Market conditions, understanding the current market dynamics and how they may impact investment decisions. A bank becomes a creditor when it lends money to an individual or business, and the borrower agrees to repay the loan plus interest. The borrower is then known as the debtor. If someone applies for a business loan to start a company, the bank that approves the loan becomes the creditor. The borrower is the debtor. If someone applies for a mortgage to buy a home, the bank that approves the loan becomes the creditor. The borrower is the debtor. Creditors and debtors. A creditor is a person or entity that lends money or provides services to another person or entity, who is then known as the debtor. Creditors are the ones who extend credit, and they expect to be repaid. Creditors can be individuals, businesses, or government bodies. Examples of creditors include banks, credit card companies, and mortgage lenders. Debtors are the ones who owe money or services to the creditor. Debtors can be individuals, businesses, or other legal entities. Creditors are individuals or entities that are owed money. Debtors are individuals or entities that owe money. Creditors typically charge interest on the money they lend. Debtors must repay the money they borrow plus interest within a specified time frame. Creditors and lenders. The terms creditor and lender are often used interchangeably. However, creditor is usually used to describe the entity that is owed money, while lender is used to describe the entity that loans the money. For example, if you borrow money from a bank and fail to repay it, then that bank may become your creditor. Also, if you take out an insurance policy with an insurance company and do not pay your premiums on time, then that insurance company becomes your creditor until such time as you pay off what you owe them. Banks buy and sell securities to generate income and increase liquidity. They may also act as a custodian for securities, managing them for clients. Buying and selling securities. Agency transactions. Banks buy and sell securities on behalf of customers, earning a commission or fee. Dealer transactions. Banks buy and sell securities for their own account. Underwriting. Investment banks buy securities from a company and sell them to investors, helping the company raise capital. Securities as investments. Liquidity. Banks buy securities to increase liquidity, which is their marketability. Capital gains. Banks profit from the difference between the price they pay for a security and the price they sell it for. Collateral. Investment-grade securities can be used as collateral to meet government deposit requirements. Securities as custodian services. Asset management. Custodian banks manage securities for clients, including reporting, compliance, and tax management. Support. Custodian banks provide support to financial institutions, pension funds, and other clients. Banks use the money you deposit into your account to make loans, buy securities, and invest in other assets. The goal is to earn a profit for the bank's owners. A general deposit is a standard deposit made into a bank account, creating a simple debtor-creditor relationship between the depositor and the bank, while a special deposit is a deposit made for a specific purpose, often with unique conditions, meaning the funds are held separately and can only be used for that designated reason, essentially creating a trust-like arrangement between the depositor and the bank. In essence, a special deposit has more restrictions and a defined purpose compared to a general deposit. Key points to remember. General deposit. Considered a standard deposit in a regular bank account. Funds can be withdrawn freely for general use. Creates a simple debtor-creditor relationship with the bank. Special deposit. Deposit made for a specific purpose, like a down payment on a property or construction funds. Funds are held separately and may have restrictions on withdrawal until a specific condition is met. Can create a trust-like relationship between the depositor and the bank. Example: general deposit. Depositing your paycheck into your checking account for everyday expenses. Special deposit. Placing a security deposit when renting an apartment, which is only released when you move out and meet the lease terms. A special deposit creates a bailment. A deposit for a specific purpose creates a trust, while a general deposit creates merely the relation of debtor and creditor. Whether there is a special deposit, a deposit for a specific purpose, or a general deposit depends upon the contract between the bank and the depositor.